Good morning, almost afternoon. I'm Catherine with LevelSet, and we're presenting a webinar today with Reese LeMieux and Michael Lane and Chris LeMieux from their New Orleans office, and they will present how bankruptcy impacts the construction project. And now I'll let Chris and Michael get started and introduce themselves and go away with the presentation.
All right. Thank you, Catherine. We are live here from New Orleans on a very gloomy day. As Catherine said, I'm Chris LeMieux. This is my partner, Mike Lane. We are with the law firm Reese LeMieux. We are predominantly a construction law firm. And so we handle these types of matters all across the Gulf South, some up on the East Coast and a little bit on the West Coast. So today we're going to be doing 30 minutes for you. It's going to be how bankruptcy impacts a construction project. And obviously, if this happens on one of your projects, it is a big problem and something you don't want to deal with. But if it does happen, hopefully we can give you some tips and pointers on what to deal with. The first thing is when you're dealing with a project, and regardless of whether it's a bankruptcy, a lien, a claim, a default, whatever it is, it always starts in the same place for me. And that place where it starts is, who are you? What is your role? How do you fit into the process? And who is around you? Because in this case, when you're dealing with a bankruptcy, it really depends on who we're dealing with. Are we dealing with an owner? Are we dealing with a lender, which we dealt with some of that in 2008, where lenders went over? Are we dealing with a developer? Are we dealing with a general contractor? Are we dealing with a sub? Are we dealing with a supplier? So it really is critical to know who you are and know where you fit in the process. Because once you understand where you fit in the process, then you can figure out what rights and remedies you have. If you're a general contractor, you have certain rights vis-a-vis the lender. If you're an owner, you have certain rights via assignments and bonding companies, surety companies. If you're a sub, you have possible rights against upstream bonds. You have possible rights with the lender. You have possible rights with the owner. You have possible statutory rights. So really, although it's incredibly basic, it really is very important from the very first and foremost. Who are you? What are the contracts that you have in place? Where do all of the various parts and pieces to the puzzle fit together? And then once you really understand that, you can move forward. And what we're going to do today is we're really going to talk about, in a very short period of time and just scratch the surface, if you're a project owner, if you're a developer, what do you do? If you're a general contractor, what do you do? If you're a subcontractor supplier, what do you do? So that's the outline we're going to follow. If you have any questions at all, certainly type them in the Q&A. If we have any time, we'll get to them at the end. If anything comes up after the fact that you have questions, you have our contact information. Feel free to email us, call us, text messages, whatever you want. Happy to respond to that.
And now we're going to start with the basics of bankruptcy. This is not a bankruptcy webinar per se, but we wanted to hit on some of the high points that are relevant to contractors and subcontractors and suppliers, because some of these terms we'll discuss throughout this presentation. And the first thing we wanted to ask is, what happens when a company files for bankruptcy? A number of things are common to all bankruptcies, regardless of the type of bankruptcy. The debtor, which is the party that files for bankruptcy, has to list their assets and liabilities when they file their petition for bankruptcy. They also have to identify any creditors that they're aware of who may have claims against their company or their estate once the bankruptcy is filed. And those creditors have to be notified of the filing. When a bankruptcy is initiated, there's an automatic stay of any actions by creditors that is put in place per the bankruptcy code. And that becomes extremely important as we talk about lien rights and other attempts to recover from the bankrupt party. Executory contracts is an important concept in bankruptcy as well. An executory contract is defined by the code as a contract that is not fully completed or performed. And we know that construction contracts during the course of a project are considered by the courts to be executory contracts. And the appointment of a trustee doesn't happen in every bankruptcy, but it happens in a lot of them, sometimes in a Chapter 11, always in a Chapter 7. And so I wanted to quickly reference there's different types of bankruptcies. There's more than what's on the screen here, but relevant for today is Chapter 7, liquidation. This is when a company is going to liquidate all of their assets to wipe out all of their debts. The company will cease to exist once that bankruptcy process plays out. Chapter 11 is a reorganization plan for a company that intends to survive the bankruptcy, come out after they've reorganized and dealt with a lot of their debt or financial difficulties. It's interesting, a lot of contractors, when they file for bankruptcy, Chapter 11 is the route that they go, and they can come out of that on the other side and reestablish themselves. And one of the things that we wanted to address here before we get into specifics of when an owner files for bankruptcy is, in a Chapter 7, the work on the project is going to stop completely. In a Chapter 11, your work may continue on that project and be subject to what's happening in the bankruptcy proceeding, but the project may be able to continue forward.
So if we look at the contractor options, if there is an owner that files bankruptcy, and again, we saw a lot of this back in 2008 when the world as we knew it basically imploded. When you're a general contractor and you're on a project, there are typically, unless it is and here we're talking about obviously private owners, there are various agreements with the lenders. And so you're going to need to get a copy of the lender agreements. Typically, when you sign up with a private project, there is typically an assignment of contract that is signed with the lender. There's also other agreements that are signed with the lender. And what those agreements usually say is, look, before you can default, or before you can place the owner in default, and before you can stop working on the project, you need to tell us, the lender, that our owner is in default. And Mike will talk a little bit later about defaults, one of it being financial insolvency and bankruptcy. But the immediate course of action is to go back and dig out those assignment documents that you signed with the lender, figure out who the lender contact is, and then have that direct communication with them, because you're going to have to put a notice to them in writing. You're going to have to ask what they want to do. And then the lender's going to have the ability to come in in essence, take over that project if they want to, because obviously the lender has expended a significant amount of sums. What you're also want to do as a general contractor is you have to be familiar with your state's lien laws. And so that is going to be number one as far as protecting your interest, you as the general contractor's interest. You're going to want to preserve that claim, because when you file a lien, you go ahead and attach a security interest to the property. Various states have rankings, and just because a mortgage may be prime in certain states, Louisiana is one of them, where even if there is a mortgage on the property, they may not necessarily rank higher than other people. The prime example are laborers. Laborers will always rank higher than mortgage companies, assuming that they've timely filed a lien. So you have to look at your state's lien laws to properly preserve that. You also have to figure out if you're going to have the ability to terminate the contract. You know, what is your ability to stop work? What is your ability to continue? What does the lender have to say about that? What is your ability to file liens? What is your ability to try to secure payment? And can you look at those rankings in various states, depending on where you are, and file liens to make sure you rank higher? Because if there is a bankruptcy and the mortgage holder is currently prime, then obviously that's going to impact your ability to get paid. But you just because an owner is going to declare bankruptcy doesn't mean that the project's over, doesn't mean that you're not going to get paid. You have various avenues through the lender, through the lien statutes, and through the contract to try to recover those sums.
And Chris referenced termination of the contract. One thing that's uniform across the country with respect to construction and bankruptcy is that you can't terminate a contract solely because the other party in that contract, whether it's the owner or the GC or a sub, has filed for bankruptcy or has insolvency issues. Now, there may be other grounds to be able to terminate if they're not able to proceed with the work or meet other obligations that they have under that contract. But the federal courts are very clear that If a party files for bankruptcy, that is not sufficient grounds for termination of a construction contract, or frankly, most contracts, including leases, franchise agreements, and many other contracts that the courts have looked at.
But if to that same token, though, that there's also other provisions in the contract regarding proof of funding. There are provisions regarding payment. There's provisions regarding security for obligations. So Mike is 100% correct that the bankruptcy in and of itself does not give grounds for termination. But what you also need to consider are there other grounds under the contract? Because chances are, if there's a bankruptcy, there's going to be payment issues, there's going to be security issues, there's also going to be funding issues. So you have to go through that agreement to see, look, although the bankruptcy may not do it by itself, are there any other basis that would allow me to go ahead and set up that termination? Again, if you're the GC, you got to go back to the lender and you have to put them on notice immediately and figure out what the lender is going to do in the process. So we talked about this earlier, and this is an important case out of the Fifth Circuit, is that the bankruptcy filing by the owner doesn't invalidate a previously recorded lien, and that the lien is going to date back, at least in this case in Louisiana, it's going to date back to the filing of the notice of contract. The filing of the notice of contract or starting to work is important because it comes back to the issue of who's prime. Again, we're looking at ranking issues a lot of times, and you, number one, obviously want to perfect your lien. You want to make sure that it's proper, but you also want it to rank higher. And so the Tuscany Reserve case is a phenomenal case because in that case, they specifically tried to state that once the owner declared bankruptcy, that the lien that was filed by the GC on that project was invalid. And the bankruptcy court specifically came in and said that it's not. In this case, it was a little snafu by the mortgage company because in Tuscany Reserve, the contractor actually filed its notice of contract prior to the mortgage company filing their mortgage. And what Tuscany Reserve said is that because the lien related back to the filing of the notice of contract, and because the notice of contract was filed prior to the mortgage, the contractor's lien had preference and priority and was valid, which is pretty significant. So, if we start looking at that, touched on the owner, what if there's a general contractor that's looking at bankruptcy? Well, number one, we talked about who are you in the process? Or are you an owner? Are you a lender? Are you a subcontractor? Are you a supplier? And so depending on who you are in the process, again, it goes back to just because they declare bankruptcy doesn't mean you may not have an avenue of payment. If it's a public job, it's a federal job, chances are the general contractor has performance and payment bonds. So even though you have a bankruptcy, you have security for those obligations. If it's a private job and they weren't required to have performance or payment bonds, maybe you actually have the ability to file a lien. So you have the ability to have a security interest. And if we go back to the ranking of privileges, if you were paying people to do labor on the job, then those labors on the job outrank anybody. So looking at who's got the ability to come in and file that lien, you need to look at those ranking scenarios because you want to make sure prior to filing that you give yourself and those funds the best ranking shot. You obviously want to place them on notice. You obviously want to talk to the surety. You obviously want to talk to the owner because in a lot of cases, if the owner defaults and terminates for, again, reasons other than bankruptcy or for whatever the reason, many of the subcontract provisions between the sub and the general have assignments. And so is the owner going to step in and take over the project? Is the lender going to step in and take over the project? Is the surety going to step in and take over the project? And if they do that, part of that is your consent to an assignment of contract. And when you do that consent, obviously you're going to have questions about payment. Am I going to be paid for these past due sums? What is the payment going to look like going forward? So just because a GC should file some type of bankruptcy doesn't mean that you don't have any tools in your tool chest. As toolbox, as a sub or supplier, you have plenty of options.
And I would want to emphasize, consult with bankruptcy counsel. It's invaluable for anybody who is dealing with a bankruptcy on the outside as a creditor to work with an attorney who really understands how the bankruptcy process works, how privileges are ranked, and how to best preserve or pursue your claim. Because one thing we haven't yet really touched on is once the bankruptcy begins, there's a proof of claim process where all creditors have to assert their claims against the estate of the debtor who's filed for bankruptcy, so the court can sort out and figure out who is going to be able to recover and how much. So asserting a proof of claim in the bankruptcy is critical in addition to your lien rights.
And look, Mike makes an excellent point on that with contacting and associating with competent bankruptcy counsel. The thing to remember is this is not a one-size-fits-all approach, and this is not a one-item approach. When you're dealing with a bankruptcy, that obviously has significant ramifications. And typically our recommendations are, if we have an avenue to get you paid, we're going to pursue that avenue. And we're not going to put all of our eggs in just one basket. We're going to process and proceed with all of the options available to you, because one of the options, quite frankly, may not work. One of the options may not be valid. But if you pursue the lien right, if you pursue the bankruptcy process, if you pursue the assignment process, if you pursue the surety bond process, the more avenues you have to get paid, the more likely it is you're going to get paid. If you put all of your eggs in one basket, you may be outranked and not get anything. So you really want to pursue everything.
And keep in mind that even if you haven't filed a lien and the bankruptcy occurs and you find out about it and you think you're too late, that's not the case. You can still perfect your lien rights by filing your lien pursuant to your state law, even after the bankruptcy petition has been filed. And that's critical because there have been cases out there discussing whether or not that violates the automatic stay, which goes into place the minute the bankruptcy is filed. But there's an important exception in the bankruptcy code that says mechanics liens, laborers liens, and those types of security interests can be filed after the bankruptcy petition initiates the bankruptcy. So once bankruptcy happens, you still have rights and you still have avenue to go protect your right to recover. One of the examples of this down here in Louisiana out of the Western District was a case where a drilling company filed for Chapter 7 liquidation. And the question was whether liens could be filed within the 180-day window under the Oil Well Lien Act that we have down here in Louisiana. And the court addressed this head on and said, yes, the exception in the bankruptcy code concerning the interests of contractors, subs, laborers, et cetera, allows them to perfect their security interest and file their liens after the bankruptcy begins. Executory contracts, we touched on this a little bit before. These are contracts that have not yet been fully performed. If a general contractor or any party on a construction project files for bankruptcy, one of the important things that they have to do in the bankruptcy itself is to decide which contracts it's going to accept or reject. If they accept it, that means that they're going to move forward with that contract and continue to comply with their obligations under that contract. This is a situation where if the GC files for bankruptcy and accepts its contract with the owner and its subs, the work is going to continue on the project. But if there's a rejection of that contract for whatever reason, that is considered a breach of the contract pre-petition, which is important because what that does is it gives you a higher ranking and a higher priority in the bankruptcy. So if a GC rejects the subcontracts on a project, the GC gives rise to claims by the subs and suppliers in the bankruptcy that are priority claims.
Proof of claim. Again, this is one of those things that is a necessity as to what you need to do. If you reach the point where the GC is not paying, again, in addition to the lien options Michael mentioned, in addition to the surety options, and in addition to the notice options, keep in mind that a proof of claim is within 70 days after the filing of the petition date, okay? So if you don't do that, it may constitute a waiver, but the waiver is not applicable when you have recorded a lien. Again, that lien gives you a security interest in that property. And we can't just stress that enough of how important that is to make your claim secured by virtue of actually attaching the lien. But again, this is a perfect example of another avenue for you potentially to get paid. So you want to make sure that you have that proof of claim is filed within 70 days, but that's not it alone. You still have to go the lien. You still have to submit the claim in compliance with the surety. And look, this is not a surety seminar today, but the surety payment bonds have very specific requirements of what you have to do, how you submit the claim, who you submit the claim to, what information is required. Again, the lien as well. Every state is different on what's required, and it's very technical and it's very precise. And if you don't comply with the statute 100%, your secured claim may become unsecured. So you really have to work with competent counsel to do all of them and do all of them correctly.
Exactly right, Chris. And one of the important things about a secured claim is that they are first in line to recover what is owed to them by the debtor. Often you don't want to be an unsecured claimant in a bankruptcy because you're at the back of the line for a party that doesn't have enough money or financial ability to pay off all their debts. So you have to get a secured claim if you can. And mechanics liens and material means liens are automatically considered secure creditors. Secured creditors, mortgage companies, others who have security rights with respect to the debtor's property, come first ahead of everyone else. And right behind that are the priority unsecured creditors, which would include wages and benefits. And then all the way at the end are the unsecured creditors fighting for the scraps. And general contractors fall into that category because they typically don't have lien rights against a subcontractor. So you have to consult with counsel, depending on your situation, to know where in the ranking of claims your claim would fall. But again, we can't stress enough, securing your lien rights is more important perhaps when a bankruptcy occurs because it puts you at the front of the line.
Yeah, and if we look at this slide again, it talks about priority unsecured creditors. So right after secured is priority, and you have a claim for unpaid wages. The interesting part about that is if you follow your state's lien process, you may take that priority unsecured creditor, make them a secured creditor, and put them number one in the ranking, because the bankruptcy court will go through the rankings of privileges. So knowing that statute, knowing the debt, and knowing how to properly make it security can put you, can take you from right in the middle to the top of the line. Subcontractor bankruptcy is obviously a problem if it happens. And so what you need to figure out once the sub declares bankruptcy is who is under them. Where do you have materials? Where do you have, again, labor that has been unpaid? Who do they owe money to? A lot of times unpacking the information as to who they've purchased materials from, who they have purchase orders with, who they have temporary labor, who they have unpaid wages with sounds a lot more it sounds a lot easier than it normally is. It's typically very complicated to figure out that mess of information, but it's something that you need to figure out. You also have to figure out where are they in the intellectual property phase of the project. Have they done their submittals? Have they done their shop drawings? What are they interacting with other trades? And again, the first step in any of these processes, it's, we don't dive in and say, okay, now we're going to the lien. We dive in to figure out who's on first. What is the information? Who do they owe money to? What's been paid? What has not been paid? What is owed? Do you have lien waivers? Do you have unpaid wages? How many unpaid wages do you have? How much is owed? And that takes some time to unpack. So you as the GC can start to figure out, number one, what your exposure is. Number two, how do you correct it? And number three, how can you move forward while this bankruptcy is pending?
We touched on this a little bit before about a termination for filing of a bankruptcy. Again, the same rule applies to subcontracts and to purchase orders or any other agreements that are considered contracts under the law. But once again, any party that doesn't comply with their other obligations, delivering materials to the site, performing their work, would be grounds for termination, not solely because of the bankruptcy. And once again, we talked about if the debtor who files for bankruptcy assumes the contract, they may be able to continue to perform the work. This doesn't always happen, of course, but if a subcontractor on your job goes under, files for bankruptcy, and if it's a Chapter 11 reorganization bankruptcy, they may be able to work with you to try to get the materials that they previously purchased and hadn't been delivered yet, delivered to the site, coordinate with the replacement contractor if they're not able to perform the work themselves despite the bankruptcy. So just be aware that there are avenues to terminate and bring in a replacement supplier or subcontractor in, but not solely because of the bankruptcy.
We touched on it earlier, again, not necessarily a surety seminar today, but an avenue to get the performance done. If there is a performance bond in place, you have to be careful because the performance bond has very specific requirements as to how you trigger the performance bond. And there are cases from all over the country that says if you don't comply with the obligations and if you don't do them properly, you won't have a right of action against the bond. And one of the requirements of the bond is putting the party in default, precondition precedent. You've got to do that. Are you going to tender the subcontract balance or contract balance to the surety? So you have very specific requirements of what to do. And if you trip up along the way and move along with somebody else without notification of the surety, without placing in default, without tendering contract balance, without complying with the very specific terms and conditions of the bond, you may take something that may turn out not that bad and lose the rights and remedies you have under that bond.
Exactly right. And one of the recent cases we've seen come out that was on point with what Chris was just saying is the notice required to the bonding company. It's absolutely critical, and it will be enforced by the courts if notice is not properly provided pursuant to the terms of the bond. This was not a bankruptcy case, but there are bankruptcy cases that hit on this point. But in this particular case that came out last year, a subcontractor terminated a subcontractor, but failed to put the surety on notice for about 8 months. And the claim was denied by the surety, of course, and then that was litigated all the way to the court. And the courts agreed with the surety because the subcontractor had not complied with the notice requirements, which sometimes are strict and have to be followed. The courts will side with the surety. They will enforce the limitations of that bond and preclude any claim against that bond.
And that really is snatching defeat from the jaws of victory. I mean, you've got the performance bond in place, you have the security in place for this very issue, and then you just airball the requirements, and those can be catastrophic.
We touched on this a little bit, the proof of claim. That's a term of art in the bankruptcy proceeding. A proof of claim is typically a form supplied by the bankruptcy court. The amount of the claim, the nature of the claim, that is all part of that form that needs to be submitted to the bankruptcy court. And before we, looks like we're running a little low on time, we wanted to touch on a few more things as potential recovery options that we haven't addressed here. One of the most important is subcontractor default insurance. We arbitrated a case just last year where that was $7 million was paid to a general contractor who had this type of insurance when the subcontractor went out of business. And they were able to recover some of that back from the subcontractor who'd gone out of business. Letters of credit and personal guarantees are other mechanisms that are in place that may allow for recovery for the party that files for bankruptcy, leaving the project and not able to satisfy their obligations.
And those are front-end risk mitigation procedures. When the party has declared bankruptcy is not the time to go ask the party for a personal guarantee. When the party has declared bankruptcy, it's not the time to get that sub-default insurance in place. So again, a lot of this comes down to risk management on the front end. Mike gave you a couple of options. With that, we are out of time. We really appreciate the 30 minutes that we had to share with you today. If you have any questions, our email is up on the screen. You can find us at rllaw.com. We thank you for your time, and we look forward to speaking with you in the near future. Thank you, everybody. We appreciate it.
Thank you.